Welcome, and thank you for joining us today. My name is Evan Marquis, and I am Business Processes Supervisor in the Corporate Finance branch. The topic of our webinar today is common filing errors, insider reporting, and the process for fee waivers for late insider reports. I'm excited to introduce our talented lineup of speakers for today's session. Breda Clifford, Branch Administrator and Acting Applications Administrator, Lorraine Greer, Prospectus Review Officer, Cheryl Antonio, Financial Examiner, Elizabeth Henry, Insider Reporting Review Officer, and Fahad Anjum, Insider Reporting Review Officer. There will be a Q&A session following the conclusion of the presentation. We will send evaluation forms at the end of the session, and we'd appreciate your feedback on this session. We'll also be sending CPD certificates via email after the session. Before we begin, I'd like to remind participants that the views expressed in this presentation are the views of corporate finance staff and do not necessarily represent the views of the Commission. The presentation is provided for general information purposes only and does not constitute legal or technical advice. Information has been summarized and paraphrased for presentation purposes, and the examples have been provided for illustration purposes only. Responsibility for making sufficient and appropriate disclosure and complying with applicable securities laws remains with the company. Information in this presentation reflects securities laws and other relevant standards that are in effect as of the date of the presentation. The contents of this presentation should not be modified without the express written permission of the presenters. The objective of the OSC SME Institute is to support small and medium-sized businesses in facilitating cost-effective compliance through issuer outreach and education. It is important for issuers to know securities regulatory requirements and to help them navigate regulatory waters. The idea is that if we can help issuers to better understand the disclosure requirements, they can focus their resources on building their company. Ultimately, we both have the same goal: for issuers to provide appropriate and meaningful information to investors. It is important to remember that at the end of the day, investor confidence in the information that companies provide is critical to the success of the company. Here is the agenda for today's presentation. The first topic will focus on common filing errors, beginning at slide 4. In this segment, we will cover exemptive relief applications at slides 5 through 10, prospectuses at slides 11 through 21, and continuous disclosure at slides 22 through 31. Our next topic will address insider reporting at slide 32. We will cover some frequently asked questions at slides 33 through 44, common filing errors at slide 45, the fee waiver process at slides 46 through 53, and issuer grant reports at slides 54 through 59. The first segment will address common filing errors. I will now pass it over to Breda, who will be walking us through some common filing errors in exemptive relief applications.
Thank you, Evan. Hello, my name is Breda Clifford, and I am the Branch Administrator and Acting Applications Administrator in the Corporate Finance branch. I am responsible for the intake of exemptive relief applications. We will now discuss common filing errors. Occasionally, filers submit applications, pre-files, and management cease trade orders incorrectly. Generally speaking, exempt relief applications should use the application's e-form portal. Notices pursuant to section 11.9 or 11.10 of National Instrument 31103 should also be filed using the same portal. Pre-filings have a separate e-form portal. This includes both applications and prospectus pre-files. Certain documents, such as notices under section 2.42 sub 2A of National Instrument 45106 and management cease trade orders, should be filed using the general portal. When you get to the electronic filing portal screen, you will be presented with a list of the different e-forms available. The arrows on this slide indicate the e-form portals we will be talking about today. Mainly 1. Applications. 2. pre-filings for prospectuses and applications. 3. The general portal / PDF submissions. Most exempt relief applications should be filed via the application's e-form, including notice pursuant to Section 11.9 or 11.10 for National Instrument 31103. To access the form, click on the application's e-form link. After you have completed the form, hit submit and you will be prompted to pay fees by credit card at the time of filing. If your fee is not paid at the time of filing, you will have to submit a check or wire transfer payable to the OSC. If your credit card payment does not go through, do not go back into the applications portal and create another submission to try and pay the fee. Also, if there is any additional amount owing after payment of the time of filing, payment must be made by check or wire transfer. Please remember to reference the submission ID number when submitting your payment. To avoid creating a duplicate filing, all revised or additional documents should be sent by email to the applications administrator at applications@osc.gov.on.ca. That wraps up my presentation on filing applications. Thanks for listening. I would be happy to take any of your questions following the completion of the presentation. At this point, I'm going to hand things over to Lorraine, who will walk you through some of the more common issues encountered when filing prospectuses.
Thank you, Brita. Hello, my name is Lorraine Greer, and I am a review officer in the Corporate Finance Branch of the OSC. Today, I will be covering common filing errors and document deficiencies. We have observed a number of common SEDAR filing deficiencies. It is required by securities legislation that all of the documents incorporated by reference are filed in all of the jurisdictions where the prospectus is filed. If you are an agent filing on behalf of an issuer, please ensure that you have access to all of your client's applicable filings. Indicate in the cover letter whether you have obtained exemptive relief from the requirement to file a document incorporated by reference in French. Remember that filing deficiencies may result in requests to refile an entire project or may delay the review of your filing. Indicating the correct filing type is another common error. Filing types cannot be corrected on SEDAR and will require the refiling of all documents as a new project and the transfer of fees. Whenever that occurs, please do not duplicate the fee payment to the OSC. These fees will need to be transferred through a written request addressed to us and filed on SEDAR. The next 3 points are concerning the issuer's submission information. The subscriber page should include the complete contact information of both filing counsel in the contact section and the person submitting the documents in the subscriber section. The omission of this information may result in difficulty reaching you to resolve potential deficiencies in a timely manner. The filing procedures section contains important details about your filing. Please specify whether your filing is a multi-jurisdictional filing under National Policy 11202, a National Instrument 44103 Post-Receipt Pricing, PREP, or an Ontario-only filing. All issuers have a principal regulator, even if the filing is an initial public offering. In that case, the principal regulator will be the agency issuing the receipt. Omitting the principal regulator may lead to a delay in receipting, as review staff will need to verify whether it is the correct regulator and might need to consult with another agency. When an incorrect fee code is used, it cannot be changed. To remedy this, a letter must be filed on SEDAR on the same project number, requesting that the fees be transferred from the incorrect fee code to the correct one. For non-investment fund prospectus filings, there are only 3 applicable fee codes. Long form, CPC would fall into the same category, short form, which would cover shelf prospectuses, and technical report. Note that technical report fees are required to be paid for each National Instrument 43101 report incorporated directly or indirectly in the prospectus or annual information form. There could be some omissions in your cover letter that may cause delays in the review of your filing. Best practice would be to include this information for review staff. The cover letter should contain the names of all current directors, officers, and promoters and the location of their personal information forms. For each individual for whom the issuer has not delivered a PIF, because a PIF or other acceptable authorization document was previously filed, should be provided. Where an issuer is submitting its first preliminary prospectus, for which the OSC will act as its principal regulator, the issuer should either file a new PIF or refile a PIF or other acceptable authorization document that was previously filed with its previous principal regulator for each applicable individual. Where an issuer has reason to believe that information contained in a PIF previously filed or delivered by an individual has materially changed, the issuer should deliver a new PIF for that individual concurrent with filing its preliminary prospectus. Also provide details on exemptive relief applications, pre-files, or previous discussions with OSC staff, if any. Make sure that the document dates are consistent. For example, the date on the qualification certificate and the National Policy 11202 letter are the same as the prospectus date. Generally, prospectuses should not be filed more than 3 days after the date on the prospectus. Personal information forms must include consents and be completed in the prescribed form. For a more detailed list of PIF submission deficiencies and other common procedural deficiencies that may cause delays in our review process, please review OSD Staff Notice 41702, Prospectus Practice Directive Number 1, Personal Information Forms and other procedural matters regarding preliminary prospectus filings. Be mindful of the 90-day window for filing a final prospectus or an amendment. Note that exemptive relief may otherwise be required. If an issuer files an amendment to a preliminary prospectus, the final prospectus must be filed within 180 days from the date of the receipt of the preliminary prospectus. Please remember to include French translations if required. Please take a moment to review some other common deficiencies as noted on this slide. We are often asked about timing of receipts. This table provides you with a quick reference guide. We do realize that there can be extenuating circumstances when you might require a special accommodation in terms of timing. In that case, please email us as soon as possible before noon. However, please note that all such requests will be reviewed on a case-by-case basis, and we cannot guarantee that the receipt will be issued at the time requested. Thank you for listening. That wraps up this component of the presentation. I would be happy to take any of your questions following the completion of the presentation. I'll now pass it over to Cheryl and the continuous disclosure segment of the presentation.
Thank you, Lorraine. My name is Cheryl Antonio, and I'm a financial examiner in the Corporate Finance Branch. In this part of the presentation, I will cover some common filing issues and general tips relating to continuous disclosure filings. Let's begin with the information provided in the cover page of a submission for an interim or annual filing. When completing a submission for interim or annual filings, filers need to indicate the continuous disclosure rule, SEDI rule, financial period ended, and the financial period date to which an interim or annual filing relates. Filers should ensure the correct SEDI rule is selected, particularly for a designated foreign issuer subject to National Instrument 71102, because this information is used to verify the issuer's filing requirements and deadlines. Please ensure the financial period ended and the financial period date relates to fields are accurate to ensure the filings are received correctly by the regulators. If incorrect information has been provided in the cover page, the cover page may be easily modified. To modify the submission cover page of an existing filing, do the following. On the Filing Management screen in SEDAR, using the cover page option on the View menu, search and select the project number of the filing, click on View and select Cover Page, go to page 2 and update the information, and submit. For more information, please refer to section 6.3 of the SEDAR Filer User Guide. Next, we will talk about certifications. When filing annual and interim financials, issuers are required to file the appropriate certificates according to National Instrument 52109. Here are some important requirements from the instrument and the related companion policy. Certificates must be filed using the exact wording prescribed by the required form, including the form number and form title. Please refer to Part 2.1 of the companion policy. The certificate must be dated the same date it is filed on SEDAR. This applies to initial or refiled certificates. Refer to Part 7 of the instrument. When refiling annual or interim financial statements, the certificate form used should be the item denoted with an R. Certification for refiled or amended annual or interim filings should be filed under the correct SEDAR filing type. For example, the refiled or amended. If an annual or interim financial statement is being refiled because of a typographical error, such as an incorrect date, it is recommended that a face page with a note to reader be added to the refiled document to explain the refiling, as both documents will remain on SEDAR. Other common errors with respect to annual filings are found in the Ontario Participation Fee Form. When filing the Participation Fee Form for Ontario, ensure the form is for the correct jurisdiction. The fee form for the Alberta Securities Commission, Form 13501, is similar to the OSC's, Form 13502. You can check if you have filed the correct form in the management certification. The Ontario fee form should be filed under the correct document type on SEDAR. If the Ontario Participation Fee Form is inadvertently filed using the Alberta Fee Form, the issuer will be asked to refile the form under the correct document type on SEDAR. Occasionally, we are asked about adding a jurisdiction as a recipient agency to an existing filing. To add a recipient agency to a previously submitted project, you may do so by filing a letter using the Add to a Filing function under the File pull-down menu from the Filing Management module. The filing should be filed under the document type of Letter Concerning Recipient Agency. The status of this letter will be private, non-public on SEDAR.com. Refer to Section 6.4 of the SEDAR Filer's User Guide for more information. Now to the issuer's SEDAR profile information. National Instrument 13101 requires issuers to maintain and update their SEDAR profile. The SEDAR profile provides vital information, including contact information that is relied upon by capital markets participants and securities regulators. We encourage issuers to review and update the information provided in their profile on a regular basis. The issuer should ensure that all information is current. In particular, contact name, business email address, principal regulator, reporting jurisdiction, auditor's information, and financial year end. This concludes my segment of the presentation. I would be happy to take any of your questions following the completion of the presentation. Thank you for listening. I will now pass it back to Evan and the Insider Reporting team.
Thank you, Cheryl. This section will cover insider reporting, common questions, issuer grant reports, and procedures for fee waivers. Some of these topics were covered in prior presentations, and some of this will be a refresh. Elizabeth will be discussing some of the more frequently asked questions OSC staff receive and hopefully provide some helpful answers. She will also address common filing errors. Fahad will guide us through insider reporting fees and the waiver request process. We hope to provide some clarity and insight for our filers regarding the circumstances where a fee waiver might be appropriate. Finally, Fahad will walk through the issuer grant report, its benefits, and reporting implications for insiders. I will now pass it over to Elizabeth.
Thank you, Evan. My name is Elizabeth Henry, and I am the Insider Reporting Review Officer in the Corporate Finance Branch. We will begin this segment by answering some important insider reporting questions in the next few slides. For your reference, you can find a definition of a reporting insider under National Instrument 55-104, Part 1. Anyone that falls under this definition is required to file insider reports on SEDI. Many insiders rely on agents to complete filings on their behalf. SEDI is the system for electronic disclosure by insiders. The access key is a case-sensitive alphanumeric code that is connected either to an insider or issuer profile supplement. It is issued once an insider profile or issuer profile supplement is created. It allows an agent, insider, or issuer representative to make a filing once the insider profile or issuer profile supplement is created. If an agent sets up a client's insider profile or issuer profile supplement, SEDI will give them the access key. If someone else sets up the client's profile information, the agent will need to request the access key from the client. When an agent is no longer filing for an insider, the insider should contact the CSA help desk to have their access key reset. As an agent, if you are no longer filing for an insider, we recommend that you request a user account deletion. Issuer profile supplements contain certain information about the issuer, particularly relating to its outstanding securities and financial instruments. It is very important that the profile contain the most up-to-date information. Profile supplements must be filed within 3 days of becoming a reporting issuer. Subsequent updates should be made immediately after any information has changed. When a new insider registered, SEDI will send a notification to the person that is listed as the insider affairs contact for the issuer. Therefore, it is important to keep that information current as well. Please refer to Section 2.3 of National Instrument 55-102 for additional information. If you already own or control directly or indirectly securities of a related financial instrument relating to SEDI issuer, you need to file your insider profile and opening balance within 10 calendar days of becoming a reporting insider. Any changes to your holding must be reported within 5 calendar days of the change. Note that if you entered into a reportable transaction within 10 calendar days of becoming a reporting insider, this may have the effect of accelerating your requirements to file an insider profile and opening balance. You can change information in the existing SEDI report by filing an amended insider report. Additional information can be added in the general remarks field if you do not want the additional information to be public. Use the private remarks to the regulators. To the extent that more information is needed, you may refer to a document already publicly disclosed on SEDAR, such as a press release or a material change report. Generally, the insider reporting requirement does not apply to an insider of a designated foreign issuer under National Instrument 71-102, provided you comply with the disclosure requirement related to insider reporting in the jurisdiction where the foreign issuer is regulated. An issuer event is defined under National Instrument 55-102 as a stock dividend, stock split, consolidation, amalgamation, reorganization, merger, or other similar events that affects all holding of a class of security of an issuer in the same manner on a per share basis. An issuer event report must be filed on SEDI no later than 1 business day following the occurrence of the event. An issuer event report is required when an event affects the entire class of securities or related financial instrument in the same manner. This may also be a material change as defined in securities legislation. If so, you will also need to file a material change report. However, not all material changes are issuer events. For example, while a company buyback of shares might be considered a material change, it would not be an issuer event. We have noticed that some insiders are not amending their profile on SEDI after they are no longer required to report. Please remember to update your profiles. You must amend your insider profile using the Add or Amend Issuer Information button to indicate the date you cease being an insider of the issuer. As an agent, if you are made aware that a person has ceased to be an insider of an issuer, please update the profile immediately. There is a detailed demonstration on how to cease reporting in a previous SME presentation dated February 22nd, 2017, which is accessible on the SME Institute, which is SME Institute website. A link to the website is referenced in Appendix A. If you no longer falls under the definition of a reporting insider under National Instrument 55-104, but you are still an insider under the Securities Act, there are no requirements to update your insider profile to reflect the change. However, we recommend that you add a public remark to your last filed transaction advising that you are no longer required to report and will cease reporting your transaction on SEDI effective the date of the change in your status. Now, we will be discussing some common filing errors. We often see problem with reporting the type of ownership. For example, not reporting by type of holding or reporting it incorrectly. Please remember to report each class of securities separately. For instance, escrow shares should be listed as a separate class of securities. For indirect ownership or control or direction holdings, please remember to report the name of the registered holder. As a reminder, you cannot correct the name of the registered holder once it's filed. Not showing both sides of the transaction is another common filing error. For example, in the case of exercise of warrants, reporting the disposition of the options and the acquisition of common shares. I am now going to pass it over to my colleague Fahad, who will discuss fees and the waiver process.
Thank you, Elizabeth. My name is Fahad Anjum, and I am the Insider Reporting Review Officer in the Corporate Finance Branch. I will be discussing filing fees and fee waiver requests. There is a fee associated with late SEDI filings to encourage timely disclosure. For insiders of reporting issuers whose principal regulator is Ontario, the late fee is $50 per calendar day per insider per issuer, subject to a maximum of $1,000 per insider per issuer within any 1 year beginning on April 1st and ending on March 31st. When submitting late fee payments by check, please remember to include a copy of the invoice. Please contact us at sedilatefees@osc.gov.on.ca for wire transfer instructions. Reporting insider or their agent can submit a late fee waiver request in writing to SEDI late fees at osc.gov.on.ca. The filer should include a copy of the invoice and provide a detailed explanation of why the late fee should be waived. The filer should also consider requesting confidentiality of the waiver request. The late fee should not be paid until a decision is made on the waiver request. No interest or penalty accrues while the decision is pending. It may take up to 15 to 25 business days for a decision to be made depending on the complexity of the request and the volume of waiver requests. Filers should note that late fee waiver requests will generally not be granted for the following reasons: unfamiliarity with the legal obligations of an insider's or agent's misunderstanding of the 5-day reporting requirement, delays caused by vacations or business trips, miscommunication between the insider and their agent or broker, or filing agent's error. Generally, OSC staff will consider late fee waiver requests in the following circumstances. Filer could have amended the original report to correct an error, but the filer deleted and filed a new report. Filer used the wrong transaction code. Filer had duplicate profiles and consolidated the two by deleting insider reports under one profile and reporting the same transactions under the other profile. On the same day, the filer filed one report to reflect the initial opening balance and another report to disclose a change in holdings, but the filer could have filed one report to disclose the total holdings as an initial opening balance. Filer used the wrong transaction date. Insider did not meet the definition of reporting insider under Section 1.1 of National Instrument 55104, and as such, an insider report was not required to be filed. OSC staff will consider the following factors in determining whether a fee waiver is appropriate. There was an automatic grant of rights or other securities which did not involve a discrete investment decision by the insider, and the insider was not informed of the automatic grant in time. Transaction required multi-step filing with the same transaction date, but represents one investment decision, or if the filer reported at least one part of the transaction within the prescribed time frame. SEDI noted an incorrect principal regulator for the reporting issuer as at the date of the transaction, and the filer received a late fee notice from the wrong jurisdiction. Insider was not informed in time that they inherited or have been gifted securities. Reporting issuer did not file security designations as required, and as a result, the filer could not file an insider report within the prescribed time frame. Note that insider-defined securities are generally discouraged. Multiple late fees were charged for transactions that were part of a market order, i.e., 2 or more transactions occurring on the same day. Insider became a deemed insider under National Instrument 55104 and had to look back 6 months and file insider reports. Filer filed an insider report, but there is an applicable reporting exemption. For example, grant of securities under a compensation arrangement, specified dispositions, issuer event, securities acquired under automatic securities purchase plans. Filer had difficulty or delays when activating user account, problems with access key resets, delays receiving assistance, etc. Filer used the date of board approval for grant of securities to the insider rather than the date on which the insider was notified of the grant. This typically applies to senior officers. We may also take into consideration other factors, including the availability of information about the transaction through other disclosure documents filed on SEDAR. We remind issuers that late fee waiver requests are considered on a case-by-case basis, and none of the other factors listed above are determinative on their own. We will now be reviewing issuer grant reports in these next slides. An issuer grant report is a report filed by an issuer on SEDI that publicly discloses the details of compensation arrangements under which grants of stock options or similar instruments are made to reporting insiders. While there is no obligation for an issuer to file an issuer grant report, it may choose to do so to assist its reporting insiders with their reporting obligations, provide the reporting insider with the benefits of an exemption from their insider reporting obligation, provided they satisfy alternative reporting requirements, and communicate material information about its compensation practices to the market in a timely manner. The issuer grant report exemption reduces the regulatory burden on reporting insiders that is associated with insider reporting of stock options and similar instruments, since it allows an issuer to make a single filing on SEDI. This filing provides the market with timely information about the existence and material terms of the grant and makes it unnecessary for each of the affected reporting insiders to file an insider report about the grant within the ordinary reporting time periods. The issuer grant report discloses the details of a compensation arrangement and must include the date of the grant, the number of options or other securities granted to each director or officer, the price at which the option or other security or related financial instrument was issued or granted and the exercise price, the number and the type of securities issuable on the exercise of the option or other security, and any other material terms that have not been previously disclosed or filed in a public filing on SEDAR. If an issuer files an issuer grant report within 5 days of a grant, award, or issue of securities, the reporting insiders named in the issuer grant report can report the grant on a deferred basis. Instead of reporting the grant within the usual 5-day reporting time frame, the reporting insiders have until March 31 of the next calendar year to report the grant or award. If subsequent to the grant and prior to March 31 of the next calendar year, the reporting insider disposes of or transfers the securities identified in the issuer grant report, other than as part of a specified disposition, the reporting insider must file an insider report within 5 days of the disposition or transfer. There is no requirement to file issuer grant reports. If an issuer chooses not to file an issuer grant report, the issuer should notify reporting insiders of a grant, award, or issue of securities in a timely manner so that those insiders can meet their individual reporting obligations within the prescribed time period. That concludes our segment on insider reporting. Thank you for listening.
I would like to thank Brita, Lorraine, Cheryl, Elizabeth, and Fahad for sharing their expertise with us today. Before we proceed to the Q&A portion, I'd like to draw your attention to the appendix in our slide deck, which contains contact information for today's presenters. So thank you very much for joining us, and please stay online for the Q&A, which will begin shortly. Also, as I mentioned at the outset, we'll be sending evaluation forms at the end of the session, and we'd appreciate your feedback. And we'll also be sending CPD certificates via email after the session. So thank you again for joining us today, and please stay online for the Q&A, which will begin shortly. Please note there may be brief delays as we review and respond to questions on a real-time basis.